Hello, and thank you for listening to this podcast. My name is Karen Killalea. I am a partner and head of the employment team at Maples and Calder, Ireland, the Maples Group's law firm in Dublin. Before we tackle today's subject, just some housekeeping. As always, if you are listening in from your usual podcast app, you'll find any resource documents and speaker information in the description. If you've clicked on the media player link sent to you by email, then you can find this information in the notes section. As always, please note this podcast contains a general overview of the regulation and use of AI in workforce practices in Ireland. It does not constitute legal advice. And if you have a specific situation or question, please do look for specific tailored legal advice. Last but not least, please don't forget to subscribe to the Irish Employment Law podcast on Apple Podcasts, Spotify, Google, or wherever you get your podcasts. I am delighted to be joined today by my colleague Claire Morrissey, who is a partner and head of the Data Commercial and Technology team here at Maples and Calder, Ireland. And the theme of today's podcast is AI regulation in workforce practices in Ireland. So just by way of preliminary introduction, along with many employers in Ireland, we have observed globally the fairly rapid adoption of AI tools across the whole of the employment lifecycle. So from recruitment and candidate screening in particular, through to performance management, workforce planning, work allocation, disciplinaries, dismissal decisions, and so forth. So I think it's safe to say we can anticipate that employers into the future will increasingly be turning to algorithmic and AI-driven systems in order to operate the entire life cycle of the employee. But that legal and regulatory landscape is evolving very quickly. And so with that in mind, I'm delighted to welcome Claire today to look at some of the following pieces, which we think will be of interest to employers in Ireland. So first of all, we're just going to look at how prevalent AI systems are in the workplace. We're going to look at the impact of the EU's AI Act. We'll talk a little bit about what employers should be doing to prepare for the AI Act implementation. And we'll close off with some tips and guidance to ensure compliance. So let's get started. Claire, welcome to the podcast. Let's talk firstly about where we see AI used in the workplace and the type of AI which many people will encounter in their day-to-day working lives.
Thank you, Karen, and thanks for having me on the podcast. Today, as you mentioned, we're seeing AI being used right across the employment life cycle. It's being used in the recruitment process, performance management, development and training, benefits management, and also in safety processes. A recent survey found that 8 out of 10 Irish employers are using AI recruitment tools. And prior to the advent of Gen AI, we've all actually been regularly interacting with machine learning in our day-to-day work. Machine learning relies on algorithms to produce the most statistically probable answer based on the information provided. And an example of this, which we've been using without even thinking about it, is the filtering of emails into spam folders based on the email address of the sender or where the content is flagged as unusual. Beyond those simple machine learning types of AI has obviously developed quite rapidly since the advent of Gen AI and in particular ChatGPT, as well as AI tools for productivity and time saving, such as Microsoft and Zoom's AI-powered transcription functions. These last two are examples of limited memory AI, where the AI systems are developed and trained to perform a specific task or desired outcome.
Perfect. Thanks, Claire. So yes, absolutely a really positive, I suppose, development in terms of efficiency tools. So that's all positive and good. And turning to regulation, not to suggest that that isn't positive and good, but the EU's AI Act was first published on the 12th of July, 2024. It has been in force since the 1st of August. Well, it's partly been in force since the 1st of August, 2024. And we're going to talk a little bit later about the staggered implementation of the Act. But just even stepping back, how important is the AI Act?
The Act itself is extremely important. It's the first of its kind globally in an effort to regulate AI. And I've heard it described as when cars or physical products are put on the market, they all have to go through some sort of safety conformity testing. And that is the EU AI Act is EU's equivalent in the context of AI. And in that context, it takes a risk-based approach to regulating AI and the AI's abilities. So it divides AI systems into four different categories. And those four categories are unacceptable risk, high risk, limited risk systems, and finally those with minimal or no risk. Unacceptable risk AI includes systems which contradict the EU's values and fundamental rights, and they're expressly prohibited. These include social scoring, that is, evaluating and characterizing people based on their social behavior, and systems which detect the emotional state of individuals. The next category, high risk. These are systems which can have a significant harm on the health, safety, and fundamental rights of people. And under the AI Act, these systems have mandatory risk mitigating functions. And most importantly, for the context of AI in the workplace, high risk systems include those which relate to recruitment and performance at work and the management of work related relationships. And we'll talk a little bit more about those later in the podcast. The third category, limited risk systems, are systems which are intended to perform a repetitive procedural task. And this can include GPAI systems. The key focus on limited risk systems is the emphasis on transparency. If one of these systems is in place, people need to be informed that they're interacting with an AI system, and any outputs it produces need to be explainable. Then finally, there are the minimal or no risk AI systems. These are largely unregulated due to their low risk nature. And for example, the previously mentioned Outlook spam filter would fall into this category.
Perfect. Okay. And just maybe picking up on one or two of the points there that you make, both about sort of fundamental rights of citizens and the interplay with AI and the EU AI Act. I suppose if we look for a moment from the employment law perspective at this, and if you look at the day-to-day use of AI in the workplace, we would certainly see that many employers in Ireland are already using AI in recruitment processes. And of course, there are significant benefits, as I was observing earlier. It's a really certainly some of the products as well that we would see in practice are just amazing efficiency tools. However, I think one of the strong criticisms of the use of AI in recruitment processes is the risk of bias, which can in turn lead to unlawful discrimination. So it's important, I suppose, just to remember that if employers do wind up unwittingly embedding discriminatory practices into their recruitment processes, that will not absolve them, if you like, from liability under the Employment Equality Acts in terms of demonstrating that the discrimination was unintentional or was mistaken. Obviously, that is not how the Employment Equality Act operates. It prohibits discrimination, as many listeners will know, on 9 different grounds, including gender, age, disability, and race. And that protection from unlawful discrimination extends, obviously, to job applicants. So, for example, if an AI system systematically screens out candidates with perhaps career gaps, this could constitute indirect discrimination on the ground of gender, as women are statistically more likely to have such career gaps on their CV or their resume as a result of caring responsibilities. So employers, as I said, could not avoid liability by arguing that the discrimination was unintentional. The focus under Irish employment equality legislation is very much on the discriminatory effect and not the intention. So it's really important to bear that in mind in circumstances where an AI recruitment tool produces a discriminatory outcome. So, Claire, having said all of that, when you consider the AI Act obligations around human oversight, data quality and monitoring. These are not really just regulatory compliance measures, but they're essential safeguards against discrimination claims. And I guess employers who implement robust governance around AI recruitment tools will, for sure, from an Irish employment law perspective, be far better positioned to defend any complaint of unlawful discrimination that may arise. So, from your perspective, is there any information on what employees think of the use of AI in the workplaces? Is this a concern for them as well?
It's interesting that you asked this, Karen. A study by the University of Reading on how employees in the UK feel about the development of AI in their workplaces found that 50% of workers felt optimistic about AI, but 61% also found it to be overwhelming to keep up with the rapid pace of AI advancements. In addition to this, while 63% of full-time workers use AI in the workplace, 49% of employees report having no guidelines at their place of work on the use of AI. And in the context of the EU AI Act, you will see that it is really important that there are guidelines, that there is a policy in place, that employees feel informed and empowered when it comes to the use of AI.
Yeah, absolutely. And that kind of aligns, I suppose, with the Irish employment law perspective. I would find that statistic quite concerning because from an employment law perspective, you absolutely need clear policies and procedures in place to govern anything from the management of performance to disciplinary to workplace investigation. So it seems absolutely key and as I say, aligned with good practice and sensible practice to make sure that employers have clear policies and procedures in place that are transparent. And that is even in workplaces where, for example, there's not very strong either trade union recognition or employee consultation frameworks. I think is a very basic piece of guidance. It is very important to ensure that there is transparency around the use of AI in the workplace and in due course, of course, and we'll talk about this later, that is not only desirable, but it is going to be a regulatory requirement. Just one other point that I'd sort of make in response to that, when you consider the AI Act's obligations on deployers to assign human oversight to persons with the necessary competence, training, and authority, and to inform employees if they will be subject to high risk AI systems. Again, these requirements align very closely with existing Irish employment law obligations around training and policies and transparency and fair procedures. So, implementing clear AI usage policies and providing that sort of comprehensive training and ensuring there are competent people overseeing that deployment. It's not just, I would say, about compliance with the AI Act, but it's also about protecting the employment relationship. It's important in terms of employee relations generally, and of course, it is an important tool in terms of mitigating legal risk from an Irish employment law perspective. Okay, so we spoke a short while ago about the staggered approach to the implementation of the AI Act in Ireland. Do you want to just take us through the key dates that employers should be aware of?
Absolutely. So, as we've mentioned, the Act itself entered into force in August 2024. The provisions on prohibited AI and AI literacy came into force on the 2nd of February this year. The provisions of the AI Act, which relate to penalties and the rules on general purpose AI models, have applied since the 2nd of August 2025. The majority of the other provisions are currently due to come into force on the 2nd of August this year. Those provisions include the provisions on high risk AI, which, as we've flagged, is particularly important for employers. However, there is currently draft regulations progressing through the EU institutions, which proposes to extend the deadline or timeline for compliance with high risk AI obligations. This legislation is known as the Digital Omnibus, and if passed, the legislation will extend the period for compliance up to the 2nd of December 2027. At the moment, it's not a
Yeah.
definite date. It's 6 months from when the Commission issues its guidelines, and at the latest, the 2nd of December 2027. So we're all eagerly following that legislation
Yeah.
to see if it's passed. will be passed on time so that organizations can benefit from that extension for compliance.
For sure, and that would be welcome. I'm guessing. Okay, all right. Maybe turning in a slightly different direction. So, looking back at the risk-based approach, what are the risk categories that you would highlight related to the employment relationship?
So there are three risk categories which will impact employment, and particularly to those working in HR and recruitment. These are unacceptable risk, high risk, and limited risk systems. In relation to unacceptable risk, as we mentioned, they're prohibited and that prohibition is currently in force, so they should never be used. From an employment perspective, these can include AI systems that infer emotions of an individual in the workplace, unless it's for a medical or safety reason. So there are three risk categories which will impact employment, particularly those working in HR or recruitment. These are unacceptable, high, and limited risk systems. In relation to unacceptable risk, as we mentioned, these are prohibited and that prohibition is currently in place. An example of this would be an AI system that infers emotions of an individual in the workplace, unless it's there for medical or safety reasons. For example, if you used an AI system to monitor candidates' emotional state during an interview, this would be a prohibited AI system. High risk AI systems, which you're likely to see in the workplace, include systems which place targets on job advertisements and filter job applications for keywords or characteristics. It also includes systems intended to make decisions on an employee's role within the company, such as promotion or termination or evaluation performance metrics. On the high risk AI systems and this staggered approach of the EU AI Act, it's worth mentioning that high risk AI systems that are placed on the market before the 2nd of August 2026 will not have to comply with the AI Act until they make a significant change to the high risk AI system. I mention this here because it will be important in the context of employers who are procuring AI recruitment tools from third party service providers. Those third party service providers will not have to comply with the EU AI Act straight away because of this grandfathering or opt out until they make a change. This will have an impact on employers if they are using a high risk AI system used by a third party that doesn't have to comply with the provisions. And it's something to be live to when you're procuring your AI related recruitment systems. Then coming back to the last category of AI risk categorization that's relevant in the employment context, these are limited risk AI systems such as chatbots. They include systems where there's a risk of impersonation of humans, and it is therefore important that employees are made aware when they're interacting with AI rather than a human.
Okay, perfect. Very good. Sorry, did I cut you off there? Did you want to?
Just one
Yeah.
postscript to that. We've just talked about the risk categories that employers should be aware of. I
Mm,
mentioned the point around when you're procuring it that it's really
mm.
important to look at the service providers' commitments, obligations, compliance obligations. Also important to be aware that the AI Act categorizes actors in the AI chain depending on their role in the development and use of AI. And for the most case, employers will be deployers, i.e.,
Right.
users of AI systems, as opposed to those who develop and place an AI system on the market for use by others.
Okay, so as deployers, are there additional obligations that those deployers of high risk AI have and that they must adhere to under the
There
Act?
certainly, Karen, and these are set out in Article 26 of the Act. And by way of high level overview, some of the obligations include implementing technical and organizational measures to ensure that the use of the high risk AI complies with the provider's instructions for use, assigning human oversight to people who have the necessary competence, training, and authority and support. If, as an employer, you control the input data, you must ensure that the data is relevant and sufficiently representative in view of the intended purpose of the system. There needs to be consistent monitoring of the AI system on the basis of the instructions of use. And where relevant, you need to provide updates to the providers of the AI system. There needs to be retention of automatically generated logs produced by the AI system for at least 6 months, unless there is a specific provision to the contrary in legislation. You need to tell employees if they're going to be subject to the use of high-risk AI systems, particularly if the decision will affect the employee directly. You need to conduct data protection impact assessments. And as with all areas of legislation, cooperate with relevant competent authorities when required to.
Perfect. Thank you. I mean, that's a fairly substantive menu of obligations. And again, it just strikes me from an Irish employment law perspective, I suppose the obligation to ensure human oversight of AI decisions intersects very nicely with a long established entitlement to fair procedures that employees have in Ireland, for example, in the context of workplace investigations and in the context of perhaps a decision to terminate the employment of an employee. So again, coming at this from the pure Irish employment law perspective, if an employer were to rely on an AI generated performance decision or recommendations regarding termination or demotion or disciplinary action, I think there would need to be an analysis of that and obviously considerable human oversight, quite apart from the obligations that you mentioned, so that the employer in Ireland is able to establish that they have in fact complied with the relevant codes of practice that govern fairness in those workplace investigations and decision making. So in other words, an employer in Ireland who were to dismiss an employee primarily on the basis of an AI recommendation without genuine and meaningful human oversight and review is likely quite exposed to a risk of finding of unfair dismissal. Um, so from what we know currently, I suppose AI can have a number of very effective uses in the workplace. It can obviously improve recruitment efficiencies. We've seen that with a number of clients who would use that by screening online applications and so forth. It can monitor performance data and improve productivity, and it can be legitimately a very strong efficiency tool in that regard. It can provide evaluation metrics to assess an employee's performance as part of that overall review that is ultimately done by a human. So there are certainly uses that are being embedded into workplace practices and have been, I would say, for quite a while. So just to be clear, are we saying these activities are no longer allowed?
No, not at all. The activities are allowed, say for the prohibited ones we mentioned. The others are just subject to regulation. And what the Act has done is they've categorized the AI systems and they've put in place, or they require users to put in place risk mitigants to ensure that both employees and employers are protected from AI negatively influencing decision making.
Okay, and in practice, do we have some examples of those risk mitigants?
And one of the most important risk mitigants is human in the loop.
Yeah.
And one of the things we have come across in advising on these issues is where a service provider says there's a human in the loop, therefore it's not high risk. And that's not approaching it from the right angle. A human in the loop is an example of a risk mitigant as opposed to changing the risk categorization that is attributed to the particular AI system that's being used. In addition to humans in the loop, the system must also be accurate, robust, and have an appropriate level of cybersecurity to protect the data involved. And record keeping is also important to ensure that the AI is instructed appropriately and that the changes are documented appropriately.
Okay, thank you for that. That's extremely helpful. And if I could just maybe turn to a subject close to all of our hearts, which is GDPR. And obviously, that's one of your areas of expertise, Claire, and we would work together very frequently on all matters GDPR. So just turning to that for a moment, from a GDPR perspective, what are the considerations that will need to be taken into account?
One of the main considerations outside of transparency, and transparency, when I mention that, I'm referring to your employee data protection notice, ensuring that that is up to date and giving clear information on how AI is used, in the context of the employee relationship. But the other provision, which is really important to highlight, is that the GDPR expressly restricts decision making that is entirely automated if the decision can have legal or significant effects on an individual. So, an example of legal or significant effects on an individual would be a decision to hire, not hire, a decision to promote, not promote. Article 22 of the GDPR restricts this type of automated decision making unless you have explicit consent, it's necessary for the performance of a contract, or it is authorized by law. If an employer does intend to implement automated decision making, the employer has to ensure that the data subject's rights, freedoms, and legitimate interests are protected. And that includes ensuring that there is human intervention, a right to ask a human to review the decision and to engage with the individual impacted. The European Commission ethics guidelines for trustworthy AI also highlights the importance of human intervention at all times, and in particular with having humans in the loop and in command.
Okay, perfect. That's extremely helpful, and obviously that just to pick up on that point about Article 22 and the prohibition on solely automated decision making with legal or significant effect is absolutely critical. It absolutely chimes with a lot of the issues that we would see in the employment context. So many employment decisions would fall squarely within that category. You know, decisions about hiring, promotion, salary increases, bonus, performance ratings, all of that, disciplinary outcomes, and obviously termination. All of these things can have a very significant effect on individual workers. Okay, well, look, that has been really helpful. Thank you so much, Claire. And before we wrap up, any final sort of tips or guidance that you would give to employers in Ireland as they navigate this new world?
I think the first and most important thing is to know what AI is being used in the context of your relationship with employees. So do an audit, figure out what's already there. And then secondly, when you're onboarding new AI tools, ensure that you have got a DDQ that asks all the right questions about the AI system in relation to how compliance with the EU AI Act is ensured. There are some caveats in the EU AI Act for high risk AI. For example, if the AI system is performing a narrow procedural task, it may fall outside of the categorization of high risk. And it'll be really important to engage with service providers of AI tools in this space to ensure that you understand how they're approaching compliance, because it will impact on the employer's compliance. The risk assessment and the auditing should be kept up to date, done on a continuous basis. And we've mentioned the obligations that deployers have. So I'd recommend that you have a checklist that you tick off to say, can I comply with each of these before you implement your AI system?
Perfect. Thanks so much. And I know that you've produced a sort of a summary of that, which we can put into the show notes. So thank you very much for all of that, Claire. Really interesting and practical guidance for employers to take note of. So for now, it just remains to thank you for listening to the Maples Group Irish Employment Law podcast. And if you have any questions or queries on any of the points covered today, or on employment legal issues in general, or the AI Act, please do get in touch with us. Thanks for listening and subscribing.